Hi, this is Kavita Saini and I am a legal intern of LEXIS and Company and I am a law student of IME Law College, and today we are going to discuss about a new topic, which is the Surrogacy Regulation Bill of 2019. The Surrogacy Regulation Bill of 2019 was introduced by the Ministry of Health and Family Welfare Dr. Harshvardhan in Lok Sabha on July 15, 2019. The bill defines surrogacy as a practice where a woman gives birth to a child for an intending couple with the intention to hand over the child after the birth to the intending couple. And there are some regulation of surrogacy in this bill, and the bill prohibits commercial surrogacy but allows altruistic surrogacy. Altruistic surrogacy involves no monetary compensation to the surrogate mother other than the medical expenses and insurance coverage during the pregnancy. And commercial surrogacy includes surrogacy or a related procedure undertaken for a monetary benefit or reward in a cash or kind exceeding the basic medical practices expenses and insurance coverage, and the purpose for which surrogacy is permitted. Surrogacy is permitted when it is for intending couples who suffer from proven infertility and altruistic, and not for commercial purpose, and not for producing children for sale and prostitution or other forms of exploitation, and for any condition or disease specified through regulation. And what are the eligibility criteria for intending couple? The intending couple should have a certificate of essentiality and certificate of eligibility by the appropriate authority. A certificate of essentiality will be issued upon the fulfillment of the following condition, like a certificate of a proven infertility of one or both member of the intending couple from district medical board, and an order of parentage and custody of the surrogate child passed by the magistrate court, and coverage postpartum and delivery complication for the surrogate. The certificate of eligibility to the intending couple is issued upon fulfillment of the following condition, like the couple being Indian citizen and married at least for 5 years, and between 23 to 50-year age, and for wife, and 26 to 55-year age for husband, and they do not have a surviving child, like biological, adopted, or surrogate. And this would not include a child who is mentally or physically challenged or suffers for life-threatening disorder, fatal illness, and condition that may be specified by regulation. And what are the eligibility criteria for a surrogate mother? And to obtain a certificate of eligibility from the appropriate authority, the surrogate mother has to be a close relative of the intending couple, and the married woman have a child of her own, and her age about to 25 to 35-year-old, a surrogate mother only once in her lifetime, and possess a certificate of medical and psychological fitness for surrogacy. Further, the surrogate mother can provide her own gametes for surrogacy. And appropriate authority, the central and the state government shall appoint one or more appropriate authorities within 19 days of the bill becoming an act. The function of the appropriate authority includes guaranteeing, suspecting, and suspending or cancelling a registration of surrogacy clinics, and enforcing standards for surrogacy clinics, and investigation and taking action breach of the provision of the bill, and recommending modification to the rules of the bills. And registration of surrogacy clinic. Surrogacy clinic cannot undertake surrogacy related procedure unless they are registered by the appropriate authority, and clinics must apply for registration within the period of 60 days from the date of appointment of the appropriate authority. National state surrogacy boards. The central and state government shall constitute the National Surrogacy Board and State Surrogacy Board respectively. And parentage and abortion of surrogate child. A child born out of a surrogacy procedure will be deemed to be the biological child of the couple, and abortion of the surrogate child requires the written consent of the surrogate mother and the authorization of the appropriate authority. And this authorization must be compliant with the Medical Termination of Pregnancy Act 1971. Further, the surrogate mother will have an option to withdraw from surrogacy before the embryo implanted in her womb. Offence and penalties are described under this bill. The offence under the bill include undertaking or advertising commercially surrogacy, exploiting the surrogate mother, abandoning, exploiting or disowning surrogate child, selling or importing human embryo or gamete for surrogacy, and the penalty for such offence is imprisonment up to 10 years and fine up to 10 lakh. And the bill specifies the range of offences and penalties for other contraventions of the provision of the bill. So that's all for today. I hope you guys like this video, so do like, share and comment and subscribe the channel. Thank you.